clear, my brother.
Great. Did you hear my question then?
Repeat it, please. Come again.
After all your advocacy and your listening to the tape and coming to the conclusion that the Attorney General had misconducted himself, even including criminal implications, and you referred to a precedent where an Attorney General suffered in a like fashion, you said he should either resign or he should be dismissed. The court has determined this matter. What do you say?
Thank you, and good morning. I don't think the court has determined the matter. There was an attempt to do a mini trial, that is a trial within the main trial. And that application says that the substantive case is still ongoing. But having said that, I think that we need to understand how the judicial process works. If a judge has jurisdiction, that is competent to try a case and come to a verdict, the judge can go right and can also go wrong. So if you have jurisdiction to do right, you also have the jurisdiction to do wrong. That is to give a positive or a negative verdict. Now, having listened to the tape this morning for a third time, I think that the Attorney General is not doing justice to the whole nation. Mind you, the Attorney General, under our Constitution, is the guardian and protector of the principle of justice. So he's the guardian and defender of the public interest. Now, here we are. If you listen to Richard Japa, he kept saying to the Attorney General, you and I, we've been discussing this matter at my cousin's house. You and I, we've been discussing this matter at my cousin's house. He doesn't tell us the number of times that the Attorney General, Godfrey Dame, and he, Richard Japa, met in Japa's cousin's house. By the number of times, that is one. Then in the course of the conversation, which was a private conversation between the two of them, we hear Richard Japa say, ask the Attorney General, how you want me to do what you're bidding, how I should go about answering questions. How I should go about answering questions. My brother, this amounts to coaching, and it's a serious offense under our law. It amounts to contempt of the court. It amounts to obstruction of justice, which is also a criminal offense under our law. Under the Constitution, any such offenses amounts to contempt of court, for which the Attorney General can be attached. I'm surprised that the defense has, up to now, not brought an application to attach the body or person of the Attorney General. Let him face the wrath of the law. What he has done is contempt of court, pure and simple, and he must be made to suffer for it. Then in the same conversation, Richard Japa reminds the Attorney General that I, Richard Japa, am innocent, and therefore I wouldn't do anything that will incriminate an innocent person merely because you want incarceration for that person or because you want your prosecution to succeed. I won't do that. He kept reminding the Attorney General. Now, arrogantly, the Attorney General comes to tell us soon after the court ruling that all the public comments, the commentators have misled the general public. It is he, the Attorney General, who has misled the court. And if we were operating in a different system, the judge would have cited the Attorney General for obstructing justice in the court, which itself also amounts to contempt of court. We have what we call in law contempt ex facie curiae, that is contempt committed before the court. So the Attorney General has tampered with a witness, and in criminal jurisprudence, we also have what is known as witness tampering. Witness tampering is any conduct of the prosecutor or defense to influence or intimidate a witness to go one way or the other. Is the Attorney General seriously suggesting that what he did not or does not amount to witness tampering?
Right.
In my considered opinion, his conduct amounts to witness tampering, and that is also contempt of court.
Mr. Ansa-Asare,
because it is an extension of obstruction of justice.
Mr. Ansa-Asare, we can deal with whether or not, as the judge, in dismissing all the applications, she makes sound law when she says, I can't find, the basis in law to give you what you are asking for in almost all of the things that they ask for. We can deal with that, but the question here has to do with what you have listened to and what she has also listened. The judge has listened to the tape 10 times. And she says, after having listened to the conversation between Richard A3 and A1, the issue of whether the Attorney General actually told A3 to implicate A1 is not borne out by the evidence on exhibits CAF2. Those words were uttered by A3 at about 9 minutes to 10. In the same vein, the declaration that A3 was innocent and, quote, going through ordeal, end quote, but was being asked to help make the case of the AG better, was not made by the Attorney General, but was made by A3, Richard Jakpa, to which the Attorney General responded. Based on the exhibit CAF2, the Attorney General is heard speaking to the third accused person. He is prosecuting outside the court and discussing the evidence and even making suggestions as to what the accused should do to obtain an adjournment. That, to my mind, may negate the principles of right thought. That said, however, the third accused cannot by any stretch of imagination be seen to be the one to be procuring new evidence or cowed by the conversation, but the whole situation could be a source of discomfort and discomfiture. What she says, as the court finds here, is the fact on the tape, is it not? To hear somebody talk about you trying to get me to help you to do your case, we don't hear it from the Attorney General. We hear it from Richard Jakpa. Is that not so?
Well, it was in response to a question. We were not there. But if the other conversationist says that repeatedly, I wouldn't want to do what you are bidding me to do. No, I wouldn't. I'm an innocent person. Now, if you ask me to do it and I implement it, the result will be this way or that way. Remember that all of us have different listening ears. What I hear from the same audio recording may be lost upon you. There are certain vital instances of assets that may be lost on you or me, that a third or fourth or fifth person may find contained in the same document or audio. So different listening here. That is one. Number two, making inferences judicially. It's not as simple as we are making it sound. The judge was legally enjoined procedurally to return findings. She has seen the witnesses, she's observed their demeanor, and she's saying that as far as she's concerned, it couldn't have been the Attorney General. The larger general public is saying that reality is different from perception. Reality is different from perception. The larger general public is saying, or majority of us are saying that we heard it loud and clear. So if the trial judge says that he needed to make a finding in order, to return a verdict, and he made it, if any person is aggrieved, the release lies in an appeal. Any other party, be the prosecution or the defense, if they feel aggrieved, let them go on appeal.
Right.
That is why we have the appeal court. They can go further to the Supreme Court.
Right.
I am not thereby suggesting that the judge's conclusion was right, but I have witnessed the discussion suggesting that if a judge can go right, the judge can go wrong.
In the manner in which the public commentary seems to project in an almost conclusive, manner that the Attorney General did wrong, is it not an invitation rather to the judge to make inferences and to make, interpretations and make conclusions from the conversation? Otherwise, what she has written down as what transpired on the tape is accurate. So people say, the Attorney General is heard saying, if you do it this way, my way, it will not pose any difficulty for you. People want the judge to make inferences from that, make conclusions out of that, and so on. Earlier, the communication from the Attorney General's department through the spokesperson was that in the meetings that were spoken about, the Attorney General simply told the witness to speak the truth. So if I ask you question A, just tell me the truth. The expectation on the judge, is it fair that she should be making inferences rather than telling us exactly what has been heard on the tape?
Thank you. Remember, in one of the interviews I granted to your station last week, I reminded the general public that the public of, the court of public opinion is overwhelmed. If you go there, you get lots and lots and lots of views. It's like watching Black Star. All of us become quote. Therefore, the judge sounded a caveat that please stop politicizing this issue. I am not going to be influenced by what you say in public. I am only going to perform my constitutional duty in accordance with the dictates of the Constitution.
All right.
The judge already sounded that. Now, where I find the judge's conclusion wrong is this. The same judge said, Mr. Attorney General, you need to be strongly advised to recuse yourself. That alone ought to have formed the basis of deciding whether to admit or not to admit, or whether to rule on the fact that the Attorney General did not say that, or the Attorney General said that. She said that he should be strongly advised. What informed that advice? What informed and
she had said,
qualified the advice.
she has said, Ms. Ansa-Asare, Ms. Ansa-Asare, she had found
moral turpitude.
Yes, she had found and said, let me supply this briefly. She had found and said that where the Attorney General is heard asking the witness to go for a medical excuse, that for her, she said, is discomforting.
My brother, the words are mere words, but words are powerful. The court was not there to decide whether a conduct will result in discomfiture or not. The court had been called upon, the court had been invited to rule on the propriety of what the Attorney General had said. All of us have heard the tape several times. I am a lawyer, and I'm saying that I find everything wrong with the conduct of the Attorney General. It is not every lawyer who is going to toe my line, and it is not every judge who is going to rule that this is, this can only amount to a discomfiture, and therefore, discomfitures, do no harm to the law, or discomfitures do not make bad cases. As far as I'm concerned.
But her point is this. You are asking me ultimately to make an order that there has been a mistrial. And she says that in our body of laws, as far as the legislation or case law is concerned, there is no provision for the court to declare a mistrial on the basis of the alleged misconduct of a lawyer, either for the prosecution or the defense. And then she says, well, if you have issues, you can go to General Legal Counsel or somewhere else, but not here. Then she says that the Attorney General is talking to the witness in the manner he's heard talking to him outside of the court at a time when he is prosecuting him in the court. It's discomforting. So on the side of the law, I can't grant what you are saying, what you are asking me to grant. But in all, propriety, it appears that something hasn't been done right.
Well, the offense of witness tampering or obstruction of justice can be committed before or during or even at a trial if it is intended to intimidate or influence the witness. It doesn't matter whether it was said in the courtroom or outside the courtroom, because outside the courtroom can be an extension of the courtroom. Here is an Attorney General leaving a courtroom, accepting an invitation to meet one of the accused persons in a private home. He shouldn't have done that. He did it. It is offense number one. Number two.
It doesn't matter. It doesn't matter that in that meeting, as they report, he was only saying, tell the truth.
But he lied.
Who lied?
He has lied. In telling Richard Japa how to go about excusing himself from the agenda itself constituted coaching. And we have remember that we have had an instance in this country where in the course of the trial of Nyantechi and Opon and Yeboah, who attempted to overthrow the NLC in 1967, in the course of the trial, one lawyer, one of the defense lawyers, S.K. Amufa, has alleged to have coached Yeboah, Opon, Nyantechi, the two of them also. And he was convicted. We have several cases where lawyers have had to appear before the General Legal Counsel, where they have suffered the sanctions laid down by law. Now, the General Legal Counsel is mandated under Section 17 of the Legal Profession Act, 1960, Act 32, to discipline erring lawyers. The Attorney General is first and foremost a lawyer, and therefore is subject to the disciplinary measures or procedures of the General Legal Council. Now,
Okay.
the General Legal Council is constituted by persons of 4 Supreme Court judges, including the Chief Justice, and the next most powerful person is the Attorney General. So the reference or referral to the General Legal Council, is called comfort. The General Legal Council, will be a toothless bulldog in this matter because the Attorney General is a stalwart in the composition of the council. I will not advise or suggest to the Defense Council to go there.
All right.
Unless the Attorney General is suspended or made to step aside. Nor the Judicial Council, because, again, the Chief Justice is the chairperson of the Judicial Council, and the next most powerful person is the Attorney General. So this creates a legal quagmire. We find ourselves in a conundrum, and the Attorney General, both the Attorney General and the court will now, find themselves in some legal tricks, like Amartedu's proverbial dilemma of a ghost. Shall I go to Cape Coast or Elmina? Should the defense go to the General Legal Council or lodge a complaint about the ruling to the Judicial Council or the Chief Justice? In neither of these instances will any good verdict.
All right. Okay, so
we will not.
You
so
clearly.
I maintain my stance that
Right.
the Attorney General must resign honorably or be fired. Now the judges advise that he should, to him, the Attorney General, that he should strongly advise himself. It is the President who has, to call the last shot, and he will not do it. And the whole nation is, sitting on tentacles. Now we have very able seniors in this country, senior lawyers in this country, who have not spoken publicly. They are rather bemoaning in their individual homes.
All right.
To their spouses and
my final question to you. My final question to you, and if I may get
let me make this point.
Okay.
We are all beneficiaries of the spoil system. Country broke or country no broke, we dey inside. Therefore, people will not talk. This is what is giving strength to our erring ministers of state on whether to resign or not to resign. Because at the end of the day, our culture in Ghana is Ehura Ebejo. Ehura Ebejo. And therefore, let them say it. They can say it 1 million times, I will not resign.
Okay.
More Kankura, not
right.
here no more.
So here's my final. Here's my final question to you, and I'd like you to be very brief with that for us. Thank you for your time. You clearly disagree with lawyers like Kwame Jan and Kwaku Pencil, who say that the Attorney General is not subject to the General Legal Council. In fact, Kwaku Pencil goes further to say that the Attorney General and his officers are not subject to the General Legal Council, which will be wrong in any case because just recently, Senior Chief State Attorney Nekwe Tete lost his license to practice as a lawyer. He's been disbarred, completely removed as a lawyer because of his involvement with Weyome, in which situation about 400,000 cedis went through his wife's bank account or so. But my question to you is this. We understand that on the day the judge was going to deliver her ruling on these applications, an application has been filed in the Supreme Court seeking to prohibit her from dealing with the applications and for certiorari on the basis that she had decided that she was not going to hear legal arguments and that denial is substantial and infringes the law, and because of that, this case should be heard by the Supreme Court and potentially all the rulings we have now that we are, discussing, will be thrown away. What do you think about that situation? That she should have allowed legal argument, and not allowing legal argument, what wrong has happened?
Friend Parmesan and Kwaku Ansa-Asare are probably wrong in suggesting that the Attorney General and the state attorney, that the crown or state lawyers are not subject. They are lawyers. The legal profession has, several branches. They belong to one branch. All of us are subject to the disciplinary control of the General Legal Counsel. So that is one. Number two, if the judge has jurisdiction to go right, the judge has jurisdiction to go wrong. This is not a matter, inviting certiorari. The Supreme Court, in certain cases or instances, may be called upon to determine certain issues. Under the Constitution, a judge, if there is an issue, with respect to interpretation of a provision, and the judge feels that the judge doesn't have the jurisdiction to do that, the judge must, or the court must refer, that issue to the Supreme Court. I am not aware that, the Supreme Court has spelled out guidelines, other than what were set out in 1987, which have been followed ever since. If you want to apply for certiorari or ask for a review, there are clear guidelines. Once your application falls within the shadow of the guidelines, then that is it.
My question is there anything wrong for a judge to say, you have filed your application, the date to move the application is this date. You don't have to move it. I'll give you my ruling. Is there anything wrong with that?
There's nothing wrong. The judge is the master and controller of the court, and the judge can invite arguments orally, that is viva or we were okay, or documentary. What she did was right.
Okay.
In my opinion.
Thank you very much. Thank you very much, Mr. Ansa-Asare.